Are you ready? I can give you a minute if you... Thank you. Let's go on the record. Good morning. My name is Michael Hammer, and I am the Commission's presiding officer designated for this hearing. This is the time and place notice for a hearing in the matter of the approval of an energy services agreement between Rocky Mountain Power and Kennecott Utah Copper LLC. That's Commission Docket number 1603533. Let's have appearances, please.
Good morning. Yvonne Hogel on behalf of Rocky Mountain Power. With me today are Steve McDougall and Paul Clements.
I'm Justin. Is that working?
Yes, I think so.
Okay. Justin Jetter, representing the Utah Division of Public Utilities, and with me at council table is Mr. Charles Peterson with the Division of Public Utilities.
Rex Olson with the Office of Consumer Services, and with me at council table is Cheryl Murray.
And I understand we have one individual participating by phone today. Is that correct?
Yes, this is Mike Wilding from Pacific North.
Thank you, Mr. Wilding. Before we move on to any other preliminary matters, we are streaming live over the internet this morning. I'm aware there has been a significant amount of confidential information filed in this docket. I don't know if any of the parties anticipate that any of that information would need to be discussed during the hearing, but please be aware that we are streaming. And if you want to address confidential information, please bring it to my attention and we can consider an appropriate motion. Are there any other preliminary matters before we begin? Okay. As it's the company's application, we'll ask the company to call its first witness.
The company calls Mr. Paul Clements.
Mr. Clements, I'm comfortable if is the court reporter comfortable if Mr. Clements stays seated where he is? Okay, then you can stay where you're at if you'd prefer. Okay.
Good morning, Mr. Clements.
Good morning.
Can you please state your name, address, and position with Rocky Mountain Power for the record?
Yes, my name is Paul Clements. My current position is consultant to Rocky Mountain Power. At the time my direct testimony was filed, my position was Director of Commercial Services for Rocky Mountain Power.
Can I just...
Yes. Proceed and then I'll keep going.
Sure. My current address is 340 East North Canyon Road in Bountiful, Utah, 84010.
Mr. Clements needs to be sworn in, by the way.
Oh, my apologies. Mr. Clements, do you swear to tell the truth?
Yes.
Thank you. Please proceed.
Thank you. And in that capacity, did you prepare or cause to be prepared direct testimony, including confidential exhibits A and B and confidential work papers, filed on August 15, 2016, in support of the company's application in this case?
Yes, I did.
And do you have any changes to your testimony?
I do not.
So if I were to ask you the questions in your testimony again here today, would your answers be the same?
Yes, they would.
Okay, at this time, I'd like to move for the admission of Mr. Clements' direct testimony, including confidential exhibits A and B and confidential work papers filed with the Commission on August 15, 2016.
Seeing no objection, they're admitted.
Thank you. The company calls its second witness, Steve McDougall.
Mr. McDougall, do you swear to tell the truth today?
Yes.
Thank you.
Can you please state your name, business address, and current position with Rocky Mountain Power?
Yes, my name is Stephen R. McDougall, and my business address is 1407 West North Temple Street, Salt Lake City, Utah, 84116. I am currently employed as the Director of Revenue Requirement for the company.
Thank you. And in that capacity, did you prepare or cause to be prepared direct testimony, including confidential exhibit A and confidential work papers, filed with the Commission on August 15, 2016, in support of the company's application in this case?
Yes, I did.
And do you have any changes to your testimony?
No, I do not.
So if I were to ask you the questions in your testimony again here today, would your answers be the same?
Yes.
Okay, and what is the purpose of your summary testimony here today?
I am here in support of the stipulation that was reached by all the signing parties in this case, including Rocky Mountain Power, the Division of Public Utilities, and the Office of Consumer Services.
And before we proceed, I'd like to move for the admission of Mr. McDougall's direct testimony, along with confidential Exhibit A and confidential work papers filed with the Commission on August 15, 2016.
They're admitted.
Thank you. Can you please describe the settlement, Mr. McDougall?
Yes. First of all, I'd like to thank the parties for the time and effort that they have dedicated to this case and the resulting stipulation we are presenting today. This stipulation was negotiated in good faith and is a reasonable and fair outcome in this docket. I'm going to walk through briefly the stipulation and touch on each of the major items. While I am going to be providing a summary of the stipulation, the language within the stipulation itself and the four corners of that document governs the agreement. The stipulation contains two confidential attachments, and a couple of paragraphs, as you have noted, do contain confidential information. I'm going to refrain from specifically referring to any of that unless there's any questions from the bench. The first 8 paragraphs of the stipulation are basically the background, and they identify a brief overview of the case, the timing of the various filings. If we start with paragraph 9, in paragraph 9, the parties request that the Commission approve the Kennecott contract as submitted and find in total, and considering the terms and conditions in the stipulation, that the contract and the stipulation are just and reasonable and in the public interest. Paragraph 10 discusses 2 confidential exhibits that the company has updated consistent with recommendations from the DPU. Exhibit A to the Energy Services Agreement was updated using a multiplier rather than specific values, and Exhibit B was updated because of a mathematical error. Paragraph 11 describes certain limitations in future proceedings related to what the company can and cannot do in any Kennecott-related proceedings, especially related to allocations. Paragraph 12 through 14 describe an agreement between the parties on the treatment of Kennecott and the energy balancing account. Specifically, in paragraph 12, that Kennecott will not be subject to the EBA and related rate changes after December 1st, 2016. The next part describes that Kennecott will be included in the EBA using the process described within paragraph 14 that basically says under step 1, we are going to calculate the EBA just as we do today, with the exceptions noted in step 2 and in paragraph 18. And step 2 states that on a monthly basis, the company will apply the Block 2 differential described in paragraph 14C to the EBA. The Block 2 differential is the difference between the that was a confidential word. The Block 2 differential is the difference as described in the settlement of the EBA. The company will be responsible for the first $350,000 of that true-up or dead band. Everything over that will be included and will be recovered from other Utah customers. Paragraph 15 describes what will happen in the next rate proceeding where this is addressed, and gives other parties the opportunity to revisit some of the accounting and to revisit the dead band. However, it states that in any such case, that other parties will not support any dead band exceeding $500,000. Paragraph 17 describes the Kennecott loads, the costs, and the revenues, and how they will be treated in interjurisdictional allocations. And then paragraph 18 describes the treatment if Kennecott serves their Block 2 as described in paragraph 5.01B3 of the contract. The remainder of the stipulation just gives general terms and conditions. In summary, the stipulation has been negotiated in good faith by all parties, and we recommend that the commission approve it as requested and find that that the agreement is in the public interest.
Does that conclude your testimony, Mr. McDougall?
Yes.
The company rests.
Thank you. Mr. Jetter, Mr. Olson, I'll give you an opportunity to ask any cross-examination questions you have of Mr. Clements or Mr. McDougall.
No questions from the division. Thank you.
None from the office.
Thank you. Then we'll proceed with the division.
Thank you. The division would like to call and have sworn in Mr. Charles Peterson.
Mr. Peterson, do you swear to tell the truth today?
Yes.
Thank you.
Mr. Peterson, would you please state your name and occupation for the record?
Charles E. Peterson. I'm a technical consultant with the Division of Public Utilities, located on the 4th floor here in this building.
And have you prepared a brief statement summarizing the division's position?
Yes, I have.
Please go ahead.
Good morning. The division recommends that the commission approve the electric service agreement as amended between Kennecott Utah Copper LLC and Pacific Corp doing business as Rocky Mountain Power, and the stipulation that was entered into by the parties as being in result just and reasonable and in the public interest. The division has studied the proposed agreement and is a party to the stipulation that was filed in this matter. The company's witnesses, Mr. Clements and Mr. McDougall, have described the contract and stipulation among the parties in some detail, so I will only make a few additional comments. As part of its review and evaluation, the division has reviewed the responses to data requests it and the Office of Consumer Services have submitted. The division also participated in technical workshops and settlement discussions with the company Rocky Mountain Power. The division had a number of concerns with the contract, including the approximate 9-year term of the contract and the apparent risks that ratepayers face as a result of the lengthy term, including the limitations to price adjustments set forth in the contract and the reliance on relatively long-term forecasts and other assumptions that went into the contract pricing. Offsetting these risks under this agreement is the risk to ratepayers of Kennecott leaving the Pacific Corp system through an action brought before the Commission under Utah Code Annotated 54.332. Such an action is now at a minimum pushed out a number of years into the future. And because Pacific Corp now has time to plan and adjust for an eventual departure of Kennecott, such a Section 32 proceeding may not ever need to be brought before the Commission. The stipulation the parties negotiated with Pacific Corp also brings some additional protections to ratepayers. In sum, the division recommends approval of the stipulation and the electric service agreement between the company and Kennecott as just and reasonable and in the public interest in result. And that concludes my statement.
Thank you. Mr. Peterson's available for cross-examination.
Ms. Hogler or Mr. Olson, any questions?
No questions.
Thank you.
We have nothing further from the division.
Thank you, Mr. Jetter. Mr. Olson?
Thank you. The office would like to call Cheryl Murray. Have her sworn, please.
Ms. Murray, do you swear to tell the truth today?
Yes.
Thank you.
Ms. Murray, could you state your name and business for the record, please?
My name is Cheryl Murray. My business address is 160 East, 300 South, Salt Lake City, Utah.
And what is your position with the office?
I'm a utility analyst.
Thank you. Did you participate in settlement discussions related to the Kennecott Electric Service Agreement under consideration here today?
Yes, Michelle Beck, the director of the office, and I participated in the negotiations.
Have you prepared testimony in support of the stipulation?
Yes.
Please proceed.
Good morning. To support our efforts to assess the implications of the Electric Service Agreement, or ESA, on interjurisdictional allocations and net power costs, the office enlisted the assistance of expert consultants Donna Ramos and Philip Hayette. The office and our consultants reviewed all testimony, exhibits, work papers, and the Electric Service Agreement provided in the company's filing. We submitted 3 sets of data requests. Our informal questions resulted in several conference calls with appropriate company personnel. In addition, we participated in technical workshops and met separately with Rocky Mountain Power and Kennecott representatives to gain an understanding of all provisions of the ESA, as well as the impact on current and future rates for our other customers. The office believes that the ESA can be found to be in the public interest in the context of the provisions described in the settlement agreement. The office would like to highlight the following important provisions from that settlement agreement. Paragraph 11. The company agrees that it will not take a position on whether costs associated with serving the Kennecott load should be included in cost allocations to Utah beyond the date of the termination of the Kennecott contract in the multi-state process, MSP, or any similar successive MSP process, including any regional or FERC process in which allocation of costs to different states or jurisdictions is addressed. It is the office's view that this provision will help mitigate future risk of an entity attempting to assign additional costs to Utah if Kennecott leaves the Rocky Mountain Power system. Paragraph 15 in part reads, the parties agree that either in the next general rate case or other appropriate proceeding, parties may propose alternative methods for the rate-making treatment of the Block 2 true-up and the deadband. The office believes that the treatment of the costs associated with the ESA as described is reasonable, but must be revisited when rates are reset so that it can be reviewed as part of a complete evaluation of rates. The future ability of parties to suggest an alternative method of accounting for the true-up of Block 2 costs is essential to the office's support of the stipulation. Taken in total, the office believes that the settlement stipulation is just and reasonable in result and in the public interest. Accordingly, we recommend commission approval.
Does that conclude your statement for
Yes,
today?
yes, it does.
Ms. Murray is available for cross-examination.
Any cross-examination from Ms. Murray?
No, thank you.
Thank you, Ms. Murray. I believe that concludes the party's presentation of evidence. Are there any other preliminary, or I should say, additional matters before we adjourn? All right. Well, the commission is aware that the existing contract is set to expire. I'm not sure if that date is confidential, so I won't enumerate it or state it here. But we're aware that the company or that the parties need an order within approximately a month, and we will do our best to get one out.
I do have one question. I wonder, I did notice that the commissioners are not present, but would hope that the hearing officer would consider a request for a bench order approving this stipulation, given that there is no opposition from any interveners and there is full support by the office. As you stated, in the interest of clarity and certainty, I believe that the fact that the new contract is vastly different from the one that is soon to be expired warrants consideration of a bench order in order for Kennecott and Rocky Mountain Power to transition into the new arrangement and agreement among them.
Does any other party have anything to say about Ms. Hogel's request for a bench ruling?
I think I could just say for the division, we have no objection to a bench ruling. We support this stipulation and approval of it, so in any form we would support it.
Same with the office. We have no objection.
Okay. Well, I think I can probably get a quorum together of the commissioners in back if we recess for a few minutes, and then I could not only potentially issue a bench ruling, but I could state whether it was approved and confirmed by the commission. So we'll be in recess for a few minutes.
Thank you.
Thank you. Let's go back on the record, please. Having considered the application, the stipulation, and accompanying exhibits and the testimony presented at hearing, the Commission finds the stipulation and the electric service agreement between Kennecott and Rocky Mountain Power to be just, reasonable, and in the public interest. The Commission therefore grants the application and approves the stipulation and the electric service agreement as amended by the stipulation. This bench order has been approved and confirmed by the Commission, and the Commission will issue a written order to memorialize it. In the meantime, the stipulation and electric service agreement are approved effective immediately and should take effect as dictated in the terms of those agreements. Do the parties have anything else before we adjourn? Thank you.